Uh, good morning, everyone. A very warm welcome to this panel. The panel is called Reorienting International Economic Law for the Digital Economy, from addressing digital divide to enabling digital development. And we have a very exciting session lined up for you this morning. My name is Neha, and I'll be moderating the session. Before I start the panel, there is a small, we have a guest rock star in our panel. So I would like to hand over to Pinar for a short while to just explain a little bit of structural deviation we are doing for this session.
Thank you very much, Neha. Good morning, everyone. It's a pleasure to have you all. There is indeed a slight or a major difference on the program. When you look at the program, the title of my presentation looks like local production. And that normally is not about data localization. I was normally supposed to talk about the localization requirement in a particular WTO case by the Turkish government for pharmaceutical production in Turkey, and that was challenged by the European Union. It was a stellar case. But then, for some reason which is unknown to the chair and the other panelists, I have been put in this session where we're supposed to talk about digital divide. And I said, for the interest of the audience, I should honor the presence of the audience to mainly talk about something digital. And I have ended up talking about another research which is very dear to my heart. It's the EU's digital product passport. So I'm going to talk about today the EU digital product passport, but my heart is still with the pharmaceuticals case. We can talk about this over the coffee break. Thank you very much for your understanding. Thanks, Neha.
Thank you so much. So the basic idea of the session is largely to understand the role and relevance of international economic law in the evolving digital economy and how it is particularly addressing the trade development nexus in the digital economy. And a lot of themes that we'll cover in the discussion actually ties with themes that have been discussed previously in different sessions and also in the keynotes. And a large part of our focus also will be on understanding how we can create a more equitable and cooperative international order, and particularly one that takes into account the needs of least developed countries and developing countries. Just to give you some background for the panel, it's very common to hear about digital divide, digital development these days, but it's important to give some meaning to these concepts. The way the panel has been structured, the idea of digital development, of course, can be broadly aligned with the notion of economic development. But when we talk about digital development, we are often talking about the expanding role of digital technologies and infrastructure in achieving socio-economic development. And in that sense, it's a multifaceted term. It can mean many things, from the existence of infrastructure to the quality, to domestic talent, to regulatory framework within the country. And digital development levels, which is again something which has been raised several times in the last 3 days, is the digital development levels really vary across countries, and that's the reason why we see digital divide. A lot of critical indicators of digital development will show how there's a huge gap between a large number of developing countries and developed countries, and particularly the gap is very significant when least developed countries are involved. And this is a big concern for international economic law, and that's the reason why we brought together this panel. Just to let you know, this panel, initially when we proposed it, it was inspired by a project that George, who's unfortunately doing another panel at the same time, George and I are doing on the role of international economic law and digital development. And in that project, we have set out 3 scenarios for how we think international economic law will be relevant for the digital economy. And while we set out these scenarios for the digital economy, I think I heard the same themes in other areas as well. The first one is where international economic law is increasingly becoming irrelevant in certain aspects. And some of the examples that have been traditionally discussed in digital trade has been how it is not always so clear how WTO principles apply in the digital context. The other second scenario is how international economic law can become a constraint to achieving digital development. And in that regard, a lot of discussions that we have heard so far has focused on policy space and whether the exceptions provide enough policy space, particularly to least developed countries and developing countries, to pursue digital development. And the third scenario, which is the optimistic scenario, which we project, is whether international economic law can be a facilitator. And an example which is often cited, and I think there was a little bit of discussion around that as well, was the role of digital economy agreements in trying to reshape certain rules of the game. So for this panel, we'll divide our discussion into 4 parts. The first part of questions will try to focus on how to understand how international economic law really applies. The second part of the panel, we look more at regional approaches, particularly focusing on Africa and Latin America. The third part, we will look at the way forward in some of these issues. And the fourth part, we will talk about digital product passport. So let's get started. Let's start with you, Rodrigo. There has been a lot of work on international trade law and digital divide, digital development, but we hear less from the international investment law side. And given that you are an expert in that field, I wanted to ask you, is it that international investment law is completely irrelevant to the issue of digital development? Could you explain a bit further?
Thank you very much, Neha. Maybe I should start pointing out some facts that for most of the audience in this room are like alien. When the first BIT was signed in 1959, the most advanced technology for telecommunications was the Princess telephone. The Princess telephone, it was a dial-up telephone, that it was for the first time very long, so it was fashionable, almost like portable. Then if you go to the heyday of investment treaties in the mid-90s, when you had 5 agreements concluded a week, when the WTO was created, so by January 1995, the top browser on internet was Netscape. How many of you know Netscape? Yeah, some of you are wondering what Netscape is. And faxes, they were actually a way of filing things. So if you think about investment treaties as the beginning and as the heyday, you will see that investment treaties, they are not digital. They were created in an analog world for brick and mortar investments, brick and mortar industries. And so the first way of answering your question, Neha, is yes, investment treaties seemingly are not really relevant for the discussion about the digital divide because they were drafted in a world where internet didn't exist in the first place, or it was not as important as it is today. Yes, you can tell me now that there are more investment treaties and some of them, they should address this digital component of our economy, but if you actually read these treaties, there are very, very few that they actually mention digital divide, digital inclusion. We will probably talk about that later in our panel. So first answer would be then no, they are not relevant. But then if you know a little bit more about investment treaties, you will know, that especially old ones, they are very, very broad. And it's like here following like an old rule of thumb. The shorter the treaty, the less policy space. Or the longer the treaty, the more policy space. And so these treaties, they have the definition of investment or the definition of investors is so broad that if you become creative or if you're a lawyer and you get paid for it, you can easily find many ways where you can have digital assets or investments in the digital economy to be characterized as protected investments or protected investors. This poses the challenge is then if we are using treaties that they were not drafted for the digital world to protect investments and investors in this new context, if the answer to these questions would be appropriate. And is in any type of incomplete contracts that especially all investment treaties are, then the answer lies on the people that adjudicate the disputes, the arbitrators in this case. I don't want to sound that there are too many cases, but they are actually. They have been, in my last count, I mean, you know, it's not so easy to know because not all these cases are public, but the ones we know, There are at least, in my count, 5 cases they deal with digital assets or digital investments or investments in the digital economy. The only one decided, as far as I know, is the Neustart versus Ambercara versus Colombia, who was decided in September last year. And this case is based on a refusal for Colombia to actually renew a .co internet domain in Colombia. I don't want to get into the specifics of the case, but it's about a domain, not about the digital asset as such. But in this case, the tribunal considered that the Colombian government did not violate any rule of domestic or international law, in particular the Fair Equitable Treatment Standard and the MFN standard of the Colombia-US TPA. There are other cases more important that are pending, notably the Huawei versus Sweden, and all others concerning a crypto company, Nexus versus Bulgaria, this was brought by a Swiss company, and Einerson versus Canada, that it deals with the data collected by satellites. And the last one is Espiritu Santo versus Mexico concerning concession of digital taximeters in Mexico City. So as you see, still, the answer is still irrelevant, but maybe the case law will change that, and maybe it will change in a way of affirming more policy space for states, or on the contrary, to give more protection to investors in these new areas of the economy. Thank you.
Thank you, Rodrigo. If I may, I have a follow-up question. So perhaps, depending on the perspective one takes, is it possible to then also argue that international investment treaties or international investment agreements can sometimes become a constraint in terms of bridging the digital divide?
I'm surprised you asked this question. Yeah, we need to pretend we didn't play out this before. Well, then again, that largely depends on 2 things. The text of the treaty, so if the treaty provides something that it could be, let's say, damaging for the purposes of overcoming the digital divide, or if the text of the treaty actually does the contrary. And I will leave that for the final part of our discussion. I understand we will deal with that. But so, if you consider that investment treaties are per se something that will affect policy space of states, and they are per se something bad from the point of view of the regulatory powers of states, then the answer is very easy. Then investment treaties, they could be something that it will constrain policies to overcome digital divide. I don't see, I would love to see the world so clear. For me, everything is very, very gray. I'm Gen X, by the way, so that's why. But there is clearly one provision on investment treaties that it could be a constraint from my point of view, and is something that is not common on the whole universe of investment treaties, but is becoming increasingly common in recent trade agreements. So the prohibition for performance requirements. You would find performance requirements is very common in the trade world. You have a whole agreement on WTO, you have the TRIMS agreement. But in the universe of investment treaties, it's actually pretty rare. If you look at the EDIT database, this is shameless plug for the database that I co-created, and we have a session right after this to show you what you can do with that. You will only find that less than 10% of investment treaties, they have prohibition of performance requirements. And the ones they have, they largely follow the TRIMS format. So you have certain performance requirements that are clearly prohibited, like local content requirement. But in new investment treaties, like notably CETA, CPTPP, the USMCA, or I'm sorry, CUSMA or TMEC, I don't want to offend anyone, and notably RCEP, you have a prohibition of performance requirements concerning technology transfer. And I put the emphasis on RCEP because in CETA, you have the EU and Canada, CPTPP, the treaty was fostered by the US and then drop it, but there is a lot of US imprint in the treaty still. The USMCA, it was negotiated between the three members, but there's a lot of imprint by the US. And RCEP, there is China, and it's the first time in my account that China includes a provision with prohibition of performance requirements concerning technology transfer. What is the meaning of this? If a state imposes a performance requirement, prohibition, a requirement of technology transfer, something that China benefited from for several years, then that, in this case, in theory, an investor could bring a claim against that government. So that definitely could be seen as a constraint. So to sum up, investment treaties could be a constraint to overcome the digital divide if we think that technology transfer is one of the elements that could help us to overcome the digital divide. And the main tool to do that, to become a constraint, would be performance requirement prohibitions that, even though they are not so common in numbers, they are becoming increasingly common in recent years in important agreements like, as mentioned, CETA, CPTPP, RCEP, and in the USMCA. And the fact that China now included that opens a whole new dimension of possibilities that this prohibition is included in other agreements.
Thank you, Rodrigo. Technology transfer is one of the most critical issues, so I'm glad you flagged that up front. And it's also concerning when the change comes from comes in a treaty where China is a party, because as you said, they have had a very different stance in the past. We'll now move to discussing a little bit about the regional approaches. Not that it's not important to discuss how international economic law is functioning at the multilateral level, but what we have seen in the recent years is a lot of development of more regional trade agreements, and that also means that certain regions are becoming much more critical in understanding the landscape. And we are very lucky because we have both Fabio and Fran, who are experts on both on Latin America and Africa. So Fabio, maybe if I can start with you. How does Latin America, and there's a lot of curiosity around this, how does Latin America really fit into the global data-driven economy?
Thank you so much. Thank you, Neha, and thank you for inviting me to this very interesting panel near very good friends. So this is a great question and one that I addressed with two other colleagues. So this is a co-authored paper with Marilia Maciel and Lucas Tasqueto, and we were trying to understand, given the very broad context of regulatory approaches to the digital divide, the digital trade, mainly the US approach, CPTPP, which I will speak more about later, the Chinese approach and the European. We wanted to understand whether or where Latin American countries would fall into these three branches, or whether they would develop a model of their own model. So that was the very general framework of the paper that I will be discussing with you today. And if I may, before I just really answer your question, our paper, the paper is going to be structured around three main answers or messages, where the first one is that Latin American countries, they are really importers of technology. So that goes into responding to your first question. And that technology comes mostly from the US and China, but also from other Asian and European countries. So this is the first message, and I'll go back to it. The second message is that Latin American countries, they are, although very numerous in terms of digital trade agreements, they are mostly rule takers. So there's no model for Latin American countries when it gets to the digital divide, and they largely replicate one particular model that I'll get into. And that, so going back to your initial point, I think that is international economic law as a constraint to development for the region. And finally, my last point will be on how we can think differently about these agreements and how we can break Latin American countries free from this constraint and thinking about other ways in which this could be regulated or maybe not regulated at all. That will be my third message. But I want to come back to my first point, which is on this, where does Latin America lie in the digital economy? And I will start and the answer with a quote that is in the paper, but comes from another quote that I know Neha is very familiar with, that says the following, that while 23% and 12% of the global data flows were attributable to China and the US, respectively, developing countries in Africa and Latin America were negligible contributors to global data flows. The United States and China, they harbor 50% of the world's hyperscale data centers and 90% of market capitalization of the largest platforms. So I think this begins my answer. And when we look at the Latin American region, we actually see something very concentrated. We're talking about e-commerce in Latin America, online shoppers, and 70% of this activity in e-commerce comes from 3 countries: Argentina, Brazil, and Mexico. And if we add 2 more countries, and that makes 70%, and if we add Chile and Colombia, we have 92% of countries that are in the e-commerce business. So that begs the question on the divide within Latin America, right? But if we have, even if for these countries that are in the region powerhouses for e-commerce, they still lack the other side of the coin here, which is infrastructure. So they lack data centers, they lack platforms, they lack infrastructure for data processing and platforms, fiscal, regulatory, and other logistical challenges. And I'll just end up with zooming in the case of Brazil, which is the jurisdiction where I come from and the one that I'm more familiar with, to make this point clear. So Brazil is now the 4th largest consumer of apps in the world and the 3rd user of social media. E-commerce in Brazil increased by 14.6% from 2023 to 2024. And e-commerce, especially sales in micro and small enterprises, increased by 1,200% in the last 5 years. So we have an economy that is booming in Brazil, but at the same time, it doesn't come accompanied by basic infrastructure. We have maybe 5 local platforms, one for e-commerce, another for finance, and then audiovisual and delivery. And so in Brazil, there's now government plans to develop, its own data centers, something that we're working on another project. But I think that sums up, gives you an image of the region to respond to your first question, Neha.
Thank you, Fabio. And I think it's a very important point that a lot of developing countries, which are actually booming digital economies, are very much dependent on very few digital powers for the basic infrastructure underlying their booming digital economies. Moving from Latin America to Africa, Fran, recently we have been discussing a lot about the AFCFTA Digital Trade Protocol. It has received significant attention amongst different kinds of policy circles, and for various reasons, some critical and some appreciative. And in your recent work, you have been focusing a lot on the interplay between competition law and digital trade. And in that regard, I was very curious to ask you a little bit more about the African context, particularly the AFCFTA competition protocol. What role do you think it can play in preventing market concentration and enabling more participation in Africa's digital economy?
It's over there.
No,
Okay.
it's working.
Okay, cool. Thanks so much. And yes, it's the odd one out, trade and competition. So let's say the Digital Trade Protocol is indeed a major step towards integrating African digital markets. but we have to look at the risks that comes for digital inclusion. And why do we look at competition law? What's the starting point for considering it is that market integration focuses usually on disciplining, state behavior, right? So it reduces trade barriers that are state imposed, at least when is it not too loud? No? I think it's weird. At least when it's based on liberalization and non-discrimination, as it is the case in the AFCFTA, and the Digital Trade Protocol from Africa even includes a non-discrimination provision, which is highly unusual for digital trade agreements. So it is based on liberalization and non-discrimination, and what it does is increasing the leeway for private actors to be active and to create beneficial situations for them, usually through anti-competitive behavior. And this is what happens. So while integration reduces state-imposed trade barriers, it gives the option for eroding all these gains while giving leeway to private actors that can do exactly the same if it's not disciplined, if it's not safeguards and controlled. So it's in two ways. It can benefit those that are already in control, most of it not African firms, but it can also give those first movers in Africa a benefit with similar exclusionary effects. So that's how competition law comes in. So the AFCFTA competition protocol actually provides an integrated continental legal framework that might, is it not working properly? It's echoing, okay. That's it? So that's not, so let me, that feels like TV now. Okay, let's continue and say that the African Competition Protocol now plays a role in addressing market concentration and a lot of abusive behavior that is commonly seen in digital markets, right? So these behaviors, we can name a few: data-driven mergers, killer acquisitions, what I have here, self-preferencing, restrictions on switching and portability, combining data across services, pre-installation requirements, all of that. So when you look at the competition protocol, there are three key provisions that can help addressing those behaviors. First, the general merger control provision that applies also to data mergers that can be used. Second, and probably the most important provision, is on abuse of economic dependence by gatekeepers. Very much modeled after the European provision. And the benefit of that is you don't have to prove dominance. You have just have a superior bargaining position to prove, and those listed gatekeepers, it's already assumed that they have the superior position. And then we have 9 listed behaviors that pretty much equal what I just mentioned: self-preferencing, pre-installing requirements that are prohibited conduct in that provision. So that is, to my mind, one of the most effective provision in Article 11. And then you have the general abusive of dominance provision that if you can prove dominance, you can actually use it as a fallback. In my mind, even look into access to essential inputs such as data or platform infrastructure, if you accept that essential facilities are not just for infrastructure, but also for critical resources. But that depends on how you interpret that. And other things like algorithmic collusion could be price fixing through automated systems and things like that. So you have these tools. How does the competition protocol now integrate the fragmented landscape in Africa? That's the question. It actually does so by creating, or filling, not creating, filling a gap at continental level for only cases with a continental dimension. That's how they call it. That means it applies only for cases where there are 2 or more African states that are not part of the same REC. It's regional economic communities, right? Only then it's actually applicable. Only then it has the jurisdiction to step in and discipline the behavior. That is, like at the integrated level, is that they establish a competition authority that has oversight over that, because there can exist concurrent jurisdiction when things like that happen. controls and cooperation and controls that states have to notify their laws and commitments. And I'm not going into detail there because also every state has to adopt now competition laws actually of national level, which not everyone has. That's the biggest problem. So it's a bottom-up multi-layered approach that can be used. As a maybe last point is it's not ignored that maybe you can actually say most African countries have difficulties in capacity to actually enforce competition laws. So what does the competition protocol do about that? It positions a requirement on the AFCFTA secretariat and the authority to provide technical assistance, and not just for the states that need it, everyone who wants it. So it is a requirement for them to do so, which gives the authority the option of actually guiding or leading the way they enforce or the way they design their laws in that way. So let me leave it here. The time is up.
Thank you, Fran. Trade and competition have had a very complicated history at the WTO, and I think with the digital economy, we are again bringing back those topics. The EU FTAs often have very comprehensive competition chapters, but otherwise it's not very common in most FTAs. And even with the EU FTAs, we haven't seen the digital dimension yet. So it's quite interesting that the competition protocol in Africa is, has adopted a lot of principles from the DMA and put it in within the architecture. Fran, if I might ask you a little bit more about the AFCFTA Digital Trade Protocol. And this is from another perspective, which is that there is this huge digital development asymmetry that we see in different parts of the world, and the same is also true for Africa. The general response has been there cannot be a one-size-fits-all approach. You need to take into account the special circumstances of each country. And then in that regard, how is the AFCFTA Digital Trade Protocol aiming to navigate the digital divides amongst African countries who have varied levels of digital readiness? Particularly, if you could throw some light on the provisions on digital inclusions and supporting MSMEs, do you think that could be effective in responding to digital inequality in Africa?
Thanks, Neha. It's pretty much the same like Fabio has outlined it for Latin America. So it's a huge internal divide between African countries that should be not neglected in the discussion of digital divides generally between Africa and the world. So it's internally, so we have 3 countries that have in 2022 contributed to more than 50% of digital delivered service exports. So only 3 African countries have done that. So that's why it's very important to focus on internal African digital divides when you look at the protocol. And there may be 3 points to highlight that the digital protocol does, and 2 that it doesn't and would have been important to do. So the first one is what you just mentioned, the digital trade inclusion chapter in the protocol. It's pretty innovative in the sense that it hasn't been done in many of the digital trade protocols so far. Only in the DEPA is that reflected. So you have an explicitly framed inclusion part in the digital trade protocol that tackles digital inclusion, MSME support, digital innovation and entrepreneurship, and digital skills. So it poses requirements. Now I'm looking at Ines, requirements to promote from a previous session yesterday, obligations to promote and support. So it's the second category in your categorization where it's imprecise what to do. But before I go into that, it's the digital skills development article is specifically interesting. It has not even been included in the DEPA, which requires that states to integrate digital skills policies into national development frameworks. So that goes beyond anything that has been seen before. Well, but it's problematic to enforce them, though, as we discussed yesterday, because benchmarks are missing. So what does mean support? What does mean promote? So you have that obligation. So that will be a challenge to enforce them. So it does fall short, that chapter, but it is a political achievement, and it's a starting point that actually digital inclusion is included, so to speak. So that's the first point. 2 further small points is technical assistance and capacity building is unusually prominent in the protocol. So you have commitments to cooperate in a wide range of areas and with like specific measures that one has to do with information exchange, joint research, training, peer review, and so it's a bit more specific, and it's replicated in the annexures that were just adopted in February. I don't think that they're publicly available, but in 6 of the 8 annexes, cooperation obligations are very much repeated and echoed. So you have a strong point on cooperation. Enforceability is the same problem, because how do you required to cooperate? What does it mean? To what extent does it go? And that, but the Secretariat has a coordinating role here, so maybe that helps again the enforcement, because they're quite active and want to be involved. And then we have transparency provisions that might build trust, but not going into that now. Maybe 2 points before ending that are missing and that should be in is, the first is the specific special and differential treatment. It is not in any other digital trade agreement, but this would have been the agreement where it should have been maybe in, because it's so significant, right? And it was requested by Uganda and Malawi, and it was rejected, and in the minutes you can see there was kind of not an interest on it and whatever. So that would have been, that's a missed opportunity, so it could have been tested and done. The second is, we have not a general exception clause in the digital trade protocol, which is unusual, and it limits the scope of just to justify digital trade measures that you actually want to do for development. I mean, you have that specifically for cross-border data flows, as is typical with public exceptions, and also for the source codes that we discussed, but not a general one. And in the light of Brazil taxation, where that would have been a possible justification, it's actually really sad that they haven't put that in. Thank you.
Friend, that's a lot of food for thought, and I think I might come back to some of these points in the next round. Fabio, I think Fran also mentioned about the Latin American perspective being a parallel example. Of course, Latin America has not adopted a continental level instrument like Africa, but there is a lot of discussion as to what should be the way forward. And I know you discussed this quite extensively in your paper as well, which you mentioned earlier. And in that regard, I wanted to ask you a little bit more on that front, is especially and I think this is asked in the Latin American context, but this is also a problem for many other countries, which is how to respond to digital trade regulation in light of existing and competing regulatory models, particularly with these digital powers like EU, US, and China having a huge influence in many developing parts of the world. So what can you share something from the Latin American perspective on that?
Sure, thank you so much, Neha. Yeah, so as I mentioned before, we were triggered about the existence of a model, and secondly, of a preference by Latin American countries, given that, I mean, I'm talking on behalf of Latin America. I have another Latin American next to me, but it's such a huge region, and it's difficult to be homogeneous, and so we're hinting at some trends in the region. So as you said, there are 3 main models that have circulated everywhere, including in Latin America. So one more, this liberal approach of the U.S. that tended, like, it was created like very much in an attempt to respond to the economic interests of the big techs. You have the EU model, which is much more on GDPR or privacy issues, and then the Chinese. Some say like it's not really a model, but initially a concern about sovereignty and security, but now we see that it's moving closer to existing models such as e-commerce facilitation. So where does that lead in terms of like how do these different models converse with Latin America, given that we don't have one? So as I said, Latin America is, countries have been very active in this digital trade lawmaking, right? So maybe you would expect some, let's say, a creativity of the countries, but that's not the pictures that we're seeing. But it's been documented in the literature that we have had 2 main groups of Latin American countries, right? One group for countries that have signed trade agreements with e-commerce chapters. Those are Chile, Colombia, Mexico, Peru. So the Pacific countries, also Costa Rica, El Salvador, Guatemala, Honduras, Panama, and the Dominican Republic. And then we have a second group of countries in Latin America that initially resisted joining e-commerce negotiations, and that is the case of Argentina, Brazil, Paraguay, Uruguay, So for those familiar with the region, those are the Mercosur countries, then Bolivia, Cuba, Ecuador, Venezuela, and the CARICOM countries. Of course, this is not a fixed picture, because even Mercosur countries have now accepted it's something very close to the model in the region. But we have historically have this differentiation, right? So the first question then is which kind of regulation comes out of this of Latin American countries in connection to third countries? I'm thinking mostly developed countries that are proposing models, agreements to Latin American countries. And then, and that speaks for the region, the US model, which becomes no longer the US model, but the CPTPP model, is by far the most influential agreement or model in the region. So you'll see it replicated in several agreements with third countries. And what does this model, in a nutshell, provide? It's about a liberal approach to data, and so they are concerned about free cross-border flow of data, banning any type of data localization measures, non-binding commitments on personal data protection rules. And some countries in the region, such as Mexico and Chile, went even further and in this liberal approach through other instruments such as the USMCA and DIPA in the case of Chile. You might be wondering what about the other models? Are they influential at all in the region? And the answer so far is, if so, very limitedly. The European and Chinese models have been less influential in the region, but there is, let's say, a track of agreements within the region with China and other Asian countries. So the Pacific Alliance and Central American countries have signed agreements containing e-commerce chapters with China, including. And then Chile, Ecuador, and Nicaragua, so individual countries have also signed some FTAs with China containing digital trade provisions. So we are able to establish that, okay, maybe the CPTPP really is the model in Latin America, in Latin American countries. But then the question becomes, what about Latin American deals, right? So what about, will they develop a different kind of regulation that maybe is more sensitive to the needs of these countries? And the short answer is no. It's a story of, unfortunately, of path dependency. They tend to apply the same model intra-region. And Chile and Mexico have been the most influential and instrumental countries in disseminating this CPTPP approach. Examples of this approach being adopted within the Latin American region are three at least. So one is in the Central American Common Market that has adopted this approach, the CAFTA-DR. The second one is the Pacific Alliance, which has an additional protocol to the framework agreement. And in the Pacific Alliance, then they go even further in the liberal approach to data and digital trade, providing elements or provisions on source code, cybersecurity, and dispute resolution, something that we don't see in other agreements. And finally, to the surprise of the first group of countries that I have introduced to you, Mercosur in 2021 has also signed an agreement on electronic commerce. And despite the historical resistance to signing agreements from these four countries, they have opted for the CPTPP. And Chile is the one to blame because Chile has negotiated individually with each one of the four Mercosur countries, including Brazil, and then they agreed to have an agreement on Mercosur agreement. So we're moving into almost like a single story in terms of but not an original one.
Our friend in the audience is reminding us that we should keep to time, so we will do our best to stick to the time. So with that thought, let me go to the last part of the discussion for this segment, which is talking a little bit more of the optimistic picture. We have so far spoken, I think, other than Fran, I think the picture was a little bit more on the negative side. Is there something that international economic law can really do to facilitate digital development and to help in addressing the digital divide? And with this question or theme in mind, Rodrigo, I wanted to come back to international investment law. How does this fit into the big picture? Can we also think of ways in which international investment agreements can contribute to digital development?
Thank you. Thank you for the question. I think the answer is yes. I mean, nowadays, seemingly, we kind of think that we can put everything on investment treaties, like on trade agreements too. Like they are somehow a way of solving the problems that we cannot have elsewhere. But there are some few but encouraging agreements that they actually deal with digital divide or digital inclusion issues. But be careful what you wish for, because sometimes these provisions, they have a nice title, but the content not necessarily is the best. So you find, for example, in several EU agreements where you have, in a very EU way, cooperation commitments to reduce the digital divide. So it's an issue you have there. We will cooperate to do this. With Central America, with the African, Caribbean, and Pacific states partnership agreement, and with the Andean community. So you have the issue of cooperation to sort out the digital divide. Digital inclusion is considered in some free trade agreements with investment chapters, like the Chile-Paraguay Free Trade Agreement, the China-Nicaragua Free Trade Agreement, and the India-United Arab Emirates CEPA, and the Asian-Australia-New Zealand FTA as modified in 2023. But again, there are provisions that not always refer explicitly to investment, and it's very much of an hortatory language, like best efforts. So it's you wonder if it's to check the box to say we care about digital inclusion, or you really want to do something about it. I think a landmark treaty by now is the treaties that Australia has concluded with the United Arab Emirates. I don't know if you are keeping tracks, but the United Arab Emirates has become, in the last 5 years, really a powerhouse treaty maker. They are signing treaties like one every month almost on trade agreements and on investment treaties. They were they were below the top 20, now are in the top 3 of countries with more agreements. And one of the issues that recurrently they deal with is digital issues. And in my count, the very first treaty, bilateral investment treaty with with digital inclusion provisions, is the Australia-United Arab Emirates BIT of 2024, that it was signed together with a free trade agreement the same year, and together with several documents, one of them particularly relevant for this case. So if you just go to the text of the treaty, it's could be seen as something encouraging, because there is, for the first time inside of an investment treaty, provisions that are supposed to deal with digital inclusion. But if you go to the text of these provisions, you will see that the provisions are basically, they have been inspired by the text of the CPTPP when it comes to data localization, and when it goes to the free flow of data, cross-border flow of data. So basically, there are provisions that, even though the title says they are there to address the digital divide, they actually encapsulate these principles that the default rule is the free flow of data, and the default rule is the prohibition of data localization. Of course, yes, exceptions that are supposed to give more policy space to states, but as you know very well, exceptions, the burden of proof is on the side of the one who claims the exception. a lot more encouraging, in the same agreement, it was concluded a memorandum of understanding on several issues, but one, and I will read you the title because it's pretty telling, between the government of United Arab Emirates and the government of Australia on investment cooperation in data centers and AI projects. So it's actually part of this agreement. And in this agreement specifically, there is areas of cooperation and implementation mechanism to actually foster the creation of data centers and artificial intelligence projects that it doesn't say explicitly, but you can see it would be at the located at the United Arab Emirates. So I think this is a good example of actually a provision that could, because positively as something concrete, actionable, how to try to overcome a digital divide from a country that is, again, is not a country that is a powerhouse when it comes to digital economy, Australia, but Australia has been in the negotiation of all the agreements pushing for to be like a rule maker on digital issues. So that's I think it's an encouraging sign. It's an evidence that actually investment treaties could be a way of facilitating the way of overcoming digital divide.
Rodrigo, and thank you for reminding us to be cautious about the influencer effect of the digital trade rules on investment law as well. Fran, I think we have mutually often discussed about the AFCFTA digital trade protocol and more broadly the treaty, and you already mentioned some features of the AFCFTA. My main question would be, what can we learn from the African experience in terms of addressing the digital divide problem in digital trade today?
Then do this again. So there are a couple of features. So thank you for asking this. Not that I didn't know, but I know. No, but there are a couple of features in there that are focused on not just the internal digital divides, but that also can maybe contribute to building domestic strategic capabilities. And one of the first, went down now. One of the first one, let's say most interesting one, is the one on rules of origin and digital products that I wanted to highlight. Because it's a new one, it hasn't been done in any digital trade agreement before, so it's unprecedented. And what it does is stipulate that the state parties need to establish rules of origin, which they have now in one of the annexes, and have defined when digital products are eligible for preferential treatment. Do a two-tier test and say when they are African content and when they are traded by any African-owned enterprise or by a different African digital platform, and then further defined in detail, which is a bit problematic how it's defined, but it's not here the issue. But what it does do is to give the option of when the moratorium, the WTO moratorium on custom duties on e-transmissions expires, which many of the African countries want, it does enable African countries to impose customs, or what would actually be the better term, taxes on cross-border data transactions, to impose them, or to maintain them, because actually they are already there. If you look at the digital service taxes, they are primarily leveled on non-residents providers of cross-border digital trade. So they are sold as internal taxes, but in actual fact, they are border measures. So they would actually contravene the moratorium. Anyway, what the aim of this was is to impose custom duties in future once the moratorium is lapsed to non-African content. So this is a major thing that African countries wanted to do. So that's one aspect. And the second aspect is that there are lots of provisions, and the one is included in the data localization provision. We spoke about this. It's the typical ban on data localization requirements with public exceptions, but it goes further and says an obligation to support the establishment and use of domestic data storage processing facilities, and that is encouraged or repeated in several annexes, including the rules of origin, where they say, you have to encourage the use of African platforms and African domestic industries. So there are a couple of features in that we can maybe look at. And when you ask about what can we learn from it, we don't know, because we don't know whether the implementation will be successful or whether actually the measures will be successful and end up in what they actually want and build those capacities. But what we can see is what African countries have in mind. What are they thinking about, what they find important, right? So they do, I would say, they find it important that it's not just liberalization, but that it's an inclusion of a developmental goal. So you can see that. You can also see that they pool together, that it means they give up, let's say, authority, regulatory space in order to tackle that where needed. And for the multilateral discussions, you know, maybe look at it, read the text as those that are in charge of the negotiations and see what they're actually interested in. I mean, there are cooperation provisions in the GSI when you look at the GSI, but very, very weak. There's nothing like technical assistance or on digital inclusion specifically. And even if it's a bit in a soft form, even if it's just like shall promote, even if it's just category 2 in Ines's categorization, it does maybe convince a few more states to participate in those discussions, because then they maybe take it more serious. So, so that's that. Obviously, there are more aspects in, but it's over the time now.
Soft law can sometimes be very useful, and one region to look at is ASEAN region, where actually a lot of soft law has led to quite a few regional cooperation and more firmer rules being built in that area. Fabio, looking forward from a Latin American perspective, and I know you already highlighted some of these issues, but really what can be done to concretely address some of these digital development concerns in future negotiations?
Great, thanks, Neha. Yeah, I forgot to say that, so in the paper we come to the conclusion that the current arrangement, the regulatory arrangement for Latin American countries leads to a development trap for these countries, because it lays restrictions on how technology can be used by developing countries and also restrains their policy space for industrial digital policies. That's something that we want to promote, right? So what can be done about it, right? So if not through regional trade agreements, are there other solutions? Or maybe one way would be stop signing any agreement with that kind of language. If you're concerned about digital development, but then I like that I'm speaking after Fran, because the insights that we got in the paper on how we could think differently about these issues, they mostly come from African countries. But before I move into these solutions, I think one way would be, like, I think thinking about bridging the digital inclusion and inequality gaps. I think we should be concerned about improving access to infrastructure and reduce gaps in knowledge. I think that would be very important, given that only 5 of the existing 379 FTAs have provisions referring to digital inclusion. And I think that effort should be put also on supporting small and medium-sized enterprises. They're very representative in the region, and only 57 out of 379 FTAs contain provisions on SMEs. We also think that we should focus, or countries should focus on development-oriented provisions. And that could be done through horizontal approaches to development-oriented provisions, meaning across the entire agreement, and then also vertical approaches. On the horizontal development orientation of these provisions, we note that FTA's provisions on capacity development and technical assistance, they are often criticized for being best efforts and non-enforceable. So we thought also we agreed with the one proposition that was put forward by Côte d'Ivoire, or Coat of Ivory, in the context of the WTO joint initiative on e-commerce, a proposal to introduce enforceable provisions inspired by the trade facilitation agreement, a proposal that happened to be weakened by the chair's text, but the enforceability of the, for instance, SDT provisions. Looking at from a vertical approach to development-oriented provisions, meaning we are focusing on a specific topic, so it's not going to be across an agreement. We also noted that so relevant exceptions to free data flows in FTAs, they're usually present in in the exceptions, right? Relevant exceptions to free data flows. They're found in three different scenarios. In the sections of dedicated to cross-border data flows, under general exceptions or security exceptions, or through direct reference to the GATS general security exceptions. But we also noted that measures aimed at the digital industrializations exceptions, they are so far absent. Another proposition more on the policy side would be to follow what Nigeria has already suggested in terms of introducing special and differential treatment to developing countries and LDCs to adopt any measure regulating cross-border data flows that they consider appropriate, and that would include, as we suggest, also measures on digital industrialization. So, yeah, so we're looking into I think we're kind of like pessimistic about FTAs in the region, and then we're more optimistic about multilateral negotiations, plurilaterals. Yeah.
That's a positive message to share. I promised you we have a rock star on the panel, so this is the opening act that you have to sit through before you get to listen to the rock star. So we're going to now discuss a little bit about the digital passport that Pinar is going to present, and it's actually quite closely connected to many digital trade issues as well, issues of cross-border data flows, data sharing, digital standards. So I wanted to ask you, the first question I wanted to ask you is, what's the relationship between sustainability, circularity, and these different digital tools that are being developed and introduced by countries? And in particular, what is the design and role of the EU's digital product passport within this framework?
Thank you very much, Neha. I was first of all fascinated by my co-panelist. It was a learning process as I was, taking notes. But I will take you a little bit to a different region. As Neha mentioned, I'm taking you now to the European Union, which is, of course, one of the trendsetters, rule setter. And I'm coming from a background as a Turkish national, as a Turkish lawyer. We have this very famous or infamous customs union agreement with the European Union, so which makes the case that the European producers, European exporters are supposed to align themselves with the EU legislation more than any third country exporters, because Turkey is also a candidate country to the EU. So the way in which I got involved in the digital product passport was actually a project which was financed by the European Union for the empowerment of the Turkish textile exporters to the EU. So it is actually a capacity building project by the European Union. It was funded by the Instrument for Pre-Accession EU funds, which were precisely given to the Turkish textile industry. And in that capacity that I started learning about the digital product passport. So coming back to Neha's question, that digital product passport actually is very much related to the European Union's Green Deal, the twin transition, both the green and digital transformation in the European Union markets, not just textile, but batteries, all products that you can imagine, have to be circular, of course. So far, many people were really amazed by the idea of the EU CBAM, but to me, the digital product passport is the real deal, because it's a true TBT instrument. It's a technical barrier to trade in order to have access to the EU market, especially important for MSMEs, because if you do not have the skills to create this digital product passport, then you cannot put your product onto the EU market. Moreover, this is also affecting a lot of the women entrepreneurs, which are the majority of the women, in particular in developing countries like Turkey, who are trying to export their products to the e-commerce. But how are they going to do this digital product passport is the main issue. So I am trying to look at this problem of why did the European Union have this digital product passport in the first place? This is going back, to, of course, to the European Green Deal and the circular economy model. The EU, from the outset, during the Ursula von der Leyen first term, tried to find out about the life cycle of a product, the material, energy which goes into it, and lately we all talked about it during the last couple of days. It also goes to the corporate social responsibility, because in this digital product passport you will also have to show to the EU customs border authorities and member state authorities where you procured the raw materials for the final product, what kind of process did it go, Did you have any women in the board of directors of your company? Is there equality? Is there respect for gender, etc.? These are all some information which is supposed to be digital, and it will also affect your digital capacity. So the way in which the European Union started, focusing on the digital product passport is actually through the textile industry, and hence the, European Union's support for capacity building in Turkey and other countries. And this is through the ESPR, the Eco-Design and Sustainability Product Regulation by the European Union, which is first, of course, not just for the textile products, but all products which are supposed to be put on the EU market have to be in conformity with certain sustainability standards and also traceability. So that's why circularity is very key here. And the digital product passport within this framework of circularity and sustainability is the key innovation under the 2024 Eco-Design for Regulation. It's not there yet, it is not compulsory, it's in the pilot project, but right now the European Commission is inviting people through the public consultation, exporters, producers, to share their views, whether they will be able to comply with this digital product passport and what kind of implications can there be. Perhaps we can touch upon this later on. Now, when you look at it, I will quickly go to this article which regulates in the ESPR, the Digital Product Passport, and with your permission, I will quote the article. It is Article 1. It says, the regulation establishes a framework for the setting of the eco-design requirements that products have to comply with to be placed on the market or put into service, with the aim of improving the environmental sustainability of products in order to make sustainable products the norm and to reduce the overall carbon footprint and environmental footprint of products over their life cycle, and ensuring free movement of sustainable products within the internal market. And then it comes the paragraph related to digital product passport and the regulation. The first article, I draw your attention, it's the most important article. It says, the regulation also establishes a digital product passport, provides for the setting of mandatory green public procurement requirements, and creates a framework to prevent unsold consumer products from being destroyed. So all of the information will go to the EU Digital Product Passport. And in that sense, when we look at it, this was decided a year ago. It was decided in July 2024. And the rule will apply. The entire rules about the eco-design and the Digital Product Passport will be applicable to all products that enter to the EU market. But of course, the EU doesn't want to create an unnecessary burdensome new TBT. So they are trying to work in partnership with third countries' businesses and support partner countries like Turkey in this endeavor. So one of the things that I can, perhaps recommend in my capacity as an academic who works with businesses in a developing country, to make sure that your businesses in your countries work in a lobbying practice with the EU counterparts, because in the majority of the cases, the company which comes from a developing country, I'll just use one, perhaps 30 seconds. The company which comes from a developing country works in cooperation with an EU company. So the best way to work, to have access to the EU market is perhaps, find collaboration with your partners in the EU and give this feedback to the European legislators and the European Commission officials to make sure that the developing country producer is not being left in the cold if they do not have this digital product passport.
Very fascinating. When you were talking, I was thinking actually some of these issues are very much replicated in the digital trade context, even in the context of digital services, where the EU has these standards, and if you don't comply with them, then you don't get to do trade with them. And because we're talking of the development dimension in this panel, I wanted to also ask you a little bit about the implications of this digital product passport initiative for Turkey, but for also other developing countries, and in particular, because you mentioned small-sized businesses for MSMEs.
Thank you very much, Neha. In particular, when you look at the statistics, the research we have done was pretty much related to the textile industry to begin with. But when you look at the textile industry, interestingly enough, it's not only in the developing countries, not only in Turkey, but in Europe as well. The majority of the companies that deal with textile industry are not big companies. Even the big textile companies are, hiring some, smaller companies to do the business for them. For instance, you may know from your own countries in the text group like Zara, Massimo Dutti, this very successful Spanish company has production chains in countries like India, Turkey, Pakistan, Bangladesh, all over the world. So these new requirements, of course, will be applicable to them. So how will these small and medium-sized enterprises will be able to comply with the Digital Product Passport initiative? So the main challenges that seems to arise is the increased transparency. Because the Digital Product Passport, the EU believes that this will create a higher transparency for the companies, but also for the European Union to make sure that certain standards are being followed by the producers and manufacturers around the world. So it's not always easy to find this information and to put into this QR code that not just the businesses will be able to use it, but also consumers. Like I always give this, example, next time you go to a shop, you buy yourself a simple T-shirt, there's a digital product passport, there will be a digital product passport. When you scan that digital product passport, lots of information will come with it. Where it was procured, when it was provided, when it was produced, how many times can you wear? If they do not fulfill their promise, let's say you said you're going to allow the consumer to wear this T-shirt at least hundreds of times, but if the consumer sees that at the end of the 50th time the T-shirt cannot be wearable anymore, then there will be extended producer liability. So that's why it's enormously important to get ready for this. And this supply chain accountability is another important factor within the Digital Product Passport, which is weighing more heavily, of course, on the developing countries. Another matter is the competitive advantage, because companies in developing countries that can meet the DPP standards will be fine, but what about those who do not have the capacity to develop that QR code, because that requires a digital awareness, that requires technical assistance, that requires money, and that requires skill setting for some people who will be working in the companies, in the factories which are producing these textile products. And therefore, when we look at all of these things, a couple of recommendations is that increased compliance requirements will actually necessitate a government involvement from the developing countries side to support the companies which are working in this field. And, perhaps good news, the EU is really supporting some, assistance in this field to comply with these requirements. At the end of the day, we all know that this is a typical example of a TBT measure. And when you look at the EPING, if you are subscribed to WTO's EPING notifications, you often see that this is discussed in the TBT committees, not just the developing country representatives in Geneva, but also the developed countries like, United States, Australia, China. Some other countries are consistently, voicing their concerns about the application of the Digital Product Passport. How will it, in fact, work? And of course, for developing countries, it brings higher costs and technical barriers more than anyone. And this digital infrastructure which is needed, it requires investment because it's not currently available. So therefore, we first need to invest in this digital infrastructure. Moreover, when you look at the eco-design regulation of the European Union, not just for textile, but also for batteries, very soon the batteries will also come into play for the Digital Product Passport. And they recommend, the European Union recommend for countries and companies to become a member of the data cloud of the European Union. So this is quite problematic. For instance, in Turkey, we have a data localization requirement. So the Turkish government actually does not allow companies to share any information in that cloud. But now if we want to trade with the EU, if a Turkish textile company wants to export its product, it will have to have access to this Digital Product Passport, and it will have to share its data in this cloud created by the European Union. So this is a concern. Another concern, which is very important, certification and auditing cost. It was already a matter with the CBAM, but now with the Digital Product Passport, the companies will also have to share this information and will certify that the products that they are producing in the country and the passport that they are creating is in conformity with it. And the risk which comes with this kind of course, obligation by the EU is the market exclusion risk. If you don't comply with it, you don't have access to the market. And the sustainability-linked finance may be an answer. So perhaps, you know, the institutions like the World Bank and the other, you know, EBRD, some other institutions may provide finance for MSMEs, because the existing data shows that, in particular in the textile industry, many companies will not have the chance to be conformity with the digital product passport. So an immediate response is required by the companies, by the countries which can, you know, provide subsidies, hopefully in a legal manner, but also the funding donor countries and the banks which may assist those companies. Thank you.
Thank you so much. I mean, it also makes us very conscious about capacity building program. And I think we have also discussed this quite a bit in digital trade, that capacity building program can take very dangerous turns, which is not in the interest of the developing countries who it's supposed to benefit. Okay, I think we've had a very, very productive discussion and a range of topics. I open the floor to questions. We still have 10 minutes, and thank you to our wonderful friend who allowed us and helped us stick to time. So perhaps we can start with you, Ines, and then Fernando. Please go ahead.
Sure, thank you. Thank you to the panel. It's very, very, very interesting. I don't have a question for a specific panelist. I think it can apply to all of them. And I'd like to take it to a bit of a higher level, because we talked about growth and development yesterday. And so I'm wondering whether the panelists could elaborate a little bit on their understanding of what is the digital divide, and what is needed or expected from treaties in this regard. Because is your position and understanding, and I'm not challenging it, it's of course it's an open question, that trade liberalization in general or digital trade specific does not help address this digital divide? So do we need to move away from trade liberalization? Do we need to put limits on that? And I'm also wondering, and this is something that relates to what Rodrigo said, but many people have said it, is that I feel like, to me, there's some disingenuity in saying that treaties that predate the internet are not useful in regulating digital trade. For example, and this relates to interpreting the digital divide as an infrastructure issue, so a lack of access to internet, a lack of access to broadband. What in the telecoms annex, for example, suggests that it doesn't apply to the internet? Why don't we use what we already have? Why don't we look at what already exists at the multilateral level? So this is I understand this is a very open-ended question, but I'd love to hear people's thoughts on that. And I have one question for Fran. Did I hear you correctly to say that you were saying that digital services taxes are border measures? And if so, I would love to hear more on that. Thank you.
Thank you, Fernando. Please go ahead.
Yeah. Well, thanks a lot for the wonderful presentations. I really enjoy and learn a lot. So my question is for Rodrigo, but then open to anyone who wants to add something. So it's about the relationship between tech transfer and the digital divide. I'm saying this because a couple of weeks ago, WTO members have a very thematic session on Article 66.2 in the Trade and Development Committee, and basically they are discussing the incentive. As you know, the 66.2 is an interesting provision because under which developed countries have to provide incentive to the companies to give technology transfer to LDCs. So my question is really, how, if you can elaborate a little bit more, Rodrigo, how you see the relationship in the context of digital. Because tech transfer now has, certainly in Geneva, is gaining so much traction. In health, we have seen it in the pandemic treaty, we are seeing in the environment, we are seeing in agriculture, and now we are seeing it in digital. But my question relates a little bit, also Franziska alluded to it, and it is the role of technical assistance. Because we do not have really technology assessments, or what are the needs of the countries to cross the border or to close the gap of the digital divide. So the technical assistance, it remains pretty much abstract. And I don't know how you see that relationship between, because the technical assistance sometimes remain pretty general. And it remains that way because countries, developing countries, do not really know what are their needs. So to give you an example, at the Secretariat, we received this reporting mechanism of the 66.2. And I have the religious experience of doing the reporting with my other colleagues. And we receive hundreds of programs that the EU and other developed countries are doing. But sometimes LDCs are very, struggle to follow, struggle to see what are the programs. So I don't know if some of you, Rodrigo or others, like to elaborate a little further on how technology transfer within the current framework could be done for the digital, to close the digital divide. So, thank you.
I think there was another question on the front.
Very briefly, my question goes to Pinar. How the whole process was affected by the events like the tragedy in the Bangladesh when the European Union just realized that most of the Zara stuff was done by kids. And, this was some kind of the input to push forward that initiative or not? That's it. Thanks.
There's another question from Magdalena.
Thank you. Okay. I have a question for Fabio, but maybe also for Franziska, because you said that South African, American countries are mainly rule takers. And yesterday there was here a discussion about global North sort of coercing global South to signing not really favorable treaties. So I would like you to dwell on a very risky, potentially risky discussion about why they choose not to include any specific for the region provisions, because from I gather there is such a path taken by African countries. And I also have a very specific question for Rodrigo, because you mentioned the localization performance requirement provision in the RCEP. And my question is how it fits with other China's obligations. I think that there is one also included in RCEP e-commerce chapter claiming there is a sort of reverse source code provision claiming that they can require localization to some extent, and that they do not that they can have restriction or source code revelation. Thank you.
Okay, we have a little bit of time, so maybe each of you, if you could take a couple of minutes and answer, and I want to make sure no one is too hungry.
So, yeah, in 1 minute, I will try to answer all the questions, of course. Ines, I don't think that treaties alone, they can help to solve the digital divide. This is like a very lawyerish idea that because you put something on a piece of paper, we want to solve the world, like peace, and peace is done. Normally, law comes afterwards, in fact. If you look at the origin of the concept of digital divide, in the beginning, it was not between countries, it was between people of different age that were not aware of the access of technology. That is the original of the word digital divide, the term digital divide. So treaties are one element. The point I make that investment treaties being analog and not digital is not to discard them. On the contrary, I think there will be more cases, and we already have 6. The point is that it's similarly when you have, for example, you have GATT, and then you decide to create GATTs because you realize that trading goods is not exactly the same as trading services. And then you say, well, GATTs, we can do digital trade with GATTs, but not everything covers GATTs, so we need to have a joint statement initiative, which is going somewhere. I don't know where exactly, but you see? So there are some things that are not captured there. And as much as they are not captured in the old treaty, then you give more power to adjudicators. And then the question is, do you trust adjudicators? And in the case of investment treaties, this is a question mark for some. Connected to your question, again, technology transfers provisions as such, they don't work if you don't have the capacity to implement that technology. You receive the technology, you don't know what to do with the technology, you don't have the knowledge, the expertise of people, then it doesn't work. So you need to have the other element. And to your question, actually the RCEP example is a bit of a fake one because there is no ISDS in RCEP. But China used the same wording. I mean, I say China like it's China's negotiating alone. Well, but you can guess. Because with Mauritius and with Guatemala, that clearly they were not the treaty makers in this case, that they included the same technology transfer prohibition, and these two treaties, they do have ISDS. So it's not a theory now, it's actually real.
Okay, I would love to take on Inez's question about whether trade liberalization is unfit for digital divide, but I think that would require a longer conversation. I'm happy to do that over coffee. So I'm going to take my Polish friend question. That's an interesting question, but my reading about the African experience, I'm directing the question to Fran too. I think some African countries or some let's say groups of African countries are promoting or are experimenting alternatives. But I'm not certain that they are not rule takers at the bilateral level so I mean maybe the experience is shared in that circumstance. In the case of Latin America, why are they accepting? I think there's a lot to do with what Francisco was saying about maybe a lot of Latin American countries do not know sometimes what they're negotiating in terms of digital trade or what is it at the table really. So I think that capacity building is really an important issue here. Other countries believe that being part of agreements, digital or trade agreements, is part of the development model, and I think I'm speaking about countries like Chile and I think there are other countries like Brazil that are more skeptical about signing treaties because maybe they feel that they can still protect some part of an industry that they are either have or are trying to promote. So I think that explains why some countries behave differently, but I think a lot has to do with countries not really aware of what is at stake and then realizing maybe too late that they have committed to things that are, let's say, there are obstacles to their digital development.
I'll share my 2 cents for both Inez's question and Francisco very briefly. I think you're very right, Inez. We should be using those. Although I have one worry in relation to the telecoms annex. I have to admit I'm not a specialist on the telecoms annex, but we all know the Indian case where they started imposing higher customs duties on mobile telecommunications equipment because the existing mobile phones are no longer the classical mobile phones that existed in 1995. So the point I'm trying to make is the existing tools, legal tools, probably would not meet the current needs. Hence, we may need to look at all these new instruments or new negotiations. But of course, I'll be happy to look at in more detail in the telecoms annex and what kind of information or lesson we can draw. For Francisco, I'll go back to my, the other case in my heart is the Turkey pharmaceutical case. There, the forced technology transfer was not existing, but there was a voluntary technology transfer. And, unfortunately, the panel decided in a different, direction. But I know from the field in Turkey that the Turkish pharmaceutical companies benefited a lot from voluntary technology transfer by some companies in Switzerland, in Canada, in the European Union. And I think this is empowering for developing countries if we can use the technology transfer in this way. And last but not least, my favorite Polish friend, the question is in relation to why the EU did. I don't think they were doing this digital product passport as a response to the developments in the Bangladesh or Pakistan. It was really, I think, genuinely was part of the EU Green Deal and digital transformation. But of course, there are also lots of claims related to Asian countries, even Turkey, how a product is being produced. We need to be responsible towards our consumers that they are consuming something which is liable and which is perhaps clean and which has not, perhaps did not, abuse the environment or human rights, etc. I think there are both ways in this question. Thank you very much.
Yeah, one can hear me, yeah. The first question to digital divide, Rodrigo has already addressed, but maybe just to add, obviously there are different levels of the digital divide, and we just use the term now generally to not have one presentation on just explaining it, but when you just look at access, use, and benefit as those different ones, I would say law can maybe play a role at the level of benefit. And when you look at the competition rules that I explained, that would just relate to who benefits how. So there it can actually play a role for sure. The other ones I'm not so sure about because it's more infrastructure investment and that kind of level. But it can encourage at least in investment in infrastructure. So it does maybe soft law rules. So they can play a role in my view to a certain extent. Coming to your question to the digital service taxes, I don't think that many like that so much, but in many aspects of them, I actually think they are border measures because they are levied on a non-residential, at least in the case of the South African case of the VAT, and in Kenya and Nigeria, on non-residential, how do you say, cross-border digital services, which means it is classical and inflow. So that aspect is simply a border measure. Therefore, it would be, if one strictly legal interpreted, it is a border measure, and therefore it falls under the customs moratorium. Whether you call it customs, I think it's a wrong term anyway, because you can't levy customs on services or electronic transmission, so you would anyway have a tax on the cross-border transaction. So that would be a classical tax. And yes, it's sold as internal, but it's partly not, partly yes.
Yeah, I think I was thinking about the Canadian and the French one. Yeah, okay. Yeah, thank you.
So yes, they are partly internal, but it depends on how they're designed. And in Africa, they are designed on non-residential ones, and therefore it's a border, and that's actually against the custom moratorium, and that is obviously not challenged because, only then it's a problem, but officially it is. So then to the global rule takers on that note, African countries have not much bilateral treaties at all in the digital space. I think Tabet, what Maria's had, we had found out that 3 maybe exist, and they are not so relevant. They're just sector specific and really don't do much. So there is nothing, and it was also recognized by the African Union Assembly as a risk in 2020, I think, so that they said we need actually to prevent that you compromise, that we can internally regulate what we want. So we want to not that you go out and say, this is what I commit to, and then you can't commit to it internally anymore because you have already a commitment elsewhere. That was exactly what they wanted to prevent, and to a large extent have done so now with the DTP because they have now it in place. So you could argue that in the negotiation process there was a lot of European involvement in terms of the funding, and that might be a rule taker in the way of influencing, right, in terms of how you think and how you create rules. And I would actually argue that to a large extent that has been the case, but that is just my personal view when I observed the negotiations, because it was questionable at times in my view. Last point on the technical assistance, actually that's a problem. So I share that with you because funding just is not a solution, because African governments will, they are corrupt and they will take it, and that's it. Let's be honest about that, straightforward. But maybe if there is a hard obligation, you actually become more creative of what can you do, how to help, because obviously also just to put somebody in again in the position and to explain how it's done elsewhere also doesn't help. That goes back to the influence, what I just said, right? So that is a challenge of how to do it, but technical assistance must be in more in terms of explaining how it's understood. So some maybe are corrupt, but there are governments out there that actually do want to know. Yeah, so smaller African governments that actually have no idea and have nothing to do with trade. And I gave the example yesterday with Ethiopian government. They're not even part of the WTO. They have no idea what they do. And then they have to sign the AFCFTA digital trade protocol and don't know what the provisions mean. So you can at least send somebody make sure that's neutral. I think that's a very important point, a bit more neutral, because so far Europeans that come to Africa and explain the world to them usually want to make a safari. That is a bad way of saying it, but it's very often what I saw. They're actually not there to really help. They're in Kenya and then they want to see game and not really help to understand. And I think that is it's more also a problem of mindset, of how you provide technical assistance. Thank you.
So big thank you to the fantastic panelists. In Hindi, we say "pet mein chuhe daud rahe hain," which means there are mice running in my stomach, which means everyone must be very, very hungry. But please join me in applauding them, and thank you for joining us.